I'm just switching everything over. Hold on a second. Hi. I just got out of the shower. I was late today. Getting everything ready. But you can see my completely just drenched hair still, because I don't own a hairdryer for some reason. But I do have some Oreos. So having an Oreo for breakfast. Because I'm an adult, and if Oreos is allowed to make cereal, I'm allowed to just have an Oreo. Oh, God. You'll have to excuse me, I had a bit of a night last night. I didn't sleep very much, so... Just one bite of that Oreo made me feel so much better. Okay. Aren't hair dryers bad for your hair? They can be if you don't, like, they can dry your hair out if you don't take care of your hair. I need a hair dryer added to my wish list. I do need to go in and update that wish list. Make some changes to it. Oh. Alright. Last time, on the last episode of Dragon Ball Z, a court case was filed. There was no response to said court case. A default was entered. Default judgment sided with Steve. Kyle was shown to be guilty of all these things due to his lack of presentation. And growing them out, I don't know. I could. They're getting kind of long. They're at that point where I could make that decision. Thank you for asking, Sheena. What? Oh, God. What was I saying? Where's my brain? I'm not awake yet. Can you tell? I'm not. Kyle then put forward a letter that was his compliance, which didn't comply with anything, and expressly explained why he wasn't going to comply. And then 2 days later, he put in a motion to dismiss the default, citing that he was never served. Of course, we played the video within his, which then also accused Steve of purposefully filing the lawsuit in the wrong place, to take advantage of the court somehow. I'm not sure how that would take advantage of the court, but listen, sometimes Steve does dumb things. Not that kind of dumb thing. He also put in that he was never served. He had that video that was clipped like crazy, and so I also played the papers that I was served. So now we get to see what Steve's lawyer's response was. So because he filed a motion, Steve's lawyer is able to respond to that motion. So we'll take a look at 21 and see what we got. Alright, everybody can see that okay? Yeah, that's zoomed in alright. Fantastic. Alright. North Carolina, part 4. Here we go. North Carolina, Guilford County, Stephen... Oh, also, in Kyle's letter to the court, he listed within that letter Shannon Q, Caitlin Chloe, Godless Engineer's wife, Godless Engineer, and Katie Joy Paulson. So, North Carolina, Guilford County, Stephen McCrae, plaintiff versus Kyle Russell Curtis, defendant in the General Court of Justice, Superior Court Division 19, CVS 8163. Response in opposition to defendant's motion to set aside default judgment. Plaintiff Stephen McCrae, through his undersigned counsel, submits this response in opposition to defendant's motion to set aside default judgment. Matter before the court. Plaintiff Stephen McRae and defendant Kyle Curtis had a partnership whereby they agreed to create and co-host a podcast which eventually came to be known as the Non-Sequitur Show. Rather than abide by the parties' agreement concerning the business, defendant Curtis took control of the show and denied access to Mr. McRae. Mr. McRae filed this lawsuit to enforce his rights and served Mr. Curtis by certified mail at the address he had used for the business and for the show. The certified mail receipts were returned, signed, and Mr. McRae filed an affidavit of service. Mr. Curtis failed to respond to the complaint, and his default was entered by court on October 3rd, 2019. The court further entered partial judgment by default on January 23rd, 2020. Oh, God. This is going to be one of those days. I should have just stayed in bed. The reason why it's a partial judgment is because, if you recall from last time, Steve was to be granted access to the books and all of the financial information so that way they could determine how much Kyle would owe Steve. So that's why it's a partial judgment, because they couldn't do the amount of money without knowing how much money was there. Defendant Curtis now claims that the address he represented to be his and to which numerous items were sent without being returned undeliverable was incorrect. So without being returned undeliverable. So if he wasn't there, essentially, and nobody signed for it, it would have come back saying, hey, I couldn't deliver this. He provides no evidence for his contention other than an affidavit stating that he moved in July of 2019 and various other items of unsworn hearsay. So that's the Benjamin Potts stuff. As argued below, Mr. Curtis clearly had notice of the complaint and opportunity to respond. His late attempt to escape the effects of his default are unavailing. Oof. Statements of relevant fact. A history of correspondence to and service of process on defendant. The complaint in this matter was filed and the summons issued on August 23, 2019, ECF number 3. The summons and complaint were served by certified mail, return receipt requested, addressed to the defendant Kyle Curtis at 1532 Providence Church Road, Pleasant Garden, North Carolina 27313. Affidavit of service of process, ECF number 7, paragraph 2. The United States Postal Service electronic tracking system indicated that the summons and complaint were served on August 30th, 2019, ID paragraph 3. The return receipt shows a signature appearing to be Susan Curtis, dated August 30th, 2018. I'm pretty sure this was 19. The Pleasant Garden address was the one used by Mr. Curtis in his dealings with Mr. McRae, McRae Affidavit, paragraph 3. For example, Mr. Curtis prepared a fictitious business name statement for filing in California, which listed his address as 1532 Providence Church Road. McRae Affidavit, paragraph 4. In addition, in email correspondence of the Non-Sequitur Show, Mr. Curtis listed 1532 Providence Church Road as his address. McRae Affidavit, paragraph 5. Property records show that 1532 Providence Church Road is now owned and has been owned by Claude and Susan Curtis, who are presumably related to defendant Kyle Curtis. Attached as Exhibit A is a true and accurate printout from the property record showing that the address has been owned by Claude and Susan Curtis since 1990. The summons and complaint were not the only items sent to the 1532 Providence Church Road address. On July 17, 2019, counsel for Mr. McRae mailed a letter to that address with electronic copies to email addresses known to be used by Mr. Curtis. A copy of that letter is attached as Exhibit B. On August 29, 2019, a notice to preserve data was sent to the same address. The email address and the email addresses. A copy of that letter is attached as Exhibit C. The affidavit of service of process and motion for entry to default were both mailed to 1532 Providence Church Road on October 2nd, 2019, ECF number 7 and 8. The motion for default judgment, ECF number 10, and the renewed motion for default judgment, ECF number 14, were mailed to the 1532 Providence Church Road address. Upon information and belief, the court mailed the order on renewed motion. The court mailed the order on renewed motion for default judgment to the 1532 Providence Church Road address, ECF number 16, paragraph 11. A copy of the court's entry of partial judgment by default, ECF number 17, was sent certified mail to the 1532 Providence Church Road address on January 27, 2020. A copy of the letter enclosing the judgment and a true and accurate copy of the certified mail return receipt is attached as Exhibit D. None of the letters listed above sent by Mr. McCrae's counsel were ever returned undeliverable or with any indication that Mr. Curtis had moved. The two items of certified mail both resulted in return receipts apparently signed by Susan Curtis, ECF number 7, and Exhibit D. Mr. Curtis never responded to any of the correspondence, either by mail or by email, to complain that his address was incorrect. Mr. Curtis clearly was receiving the various pleadings and correspondence. In online interviews, Mr. Curtis referenced the lawsuit and indicated that he had not responded. McCrae Affidavit, paragraph 7. On February 4th, 2020, Mr. Curtis submitted a document to the court titled Compliance to the Order, in which Mr. Curtis purported to comply with the court's entry of partial judgment by default, ECF number 18. Mr. Curtis would only have known to file such a response if he was getting copies of the various filings. Oh, this is so awkward. Can I just talk about real quick how much I love Ash? Ash, I love you. You kill me. Defendant's evidence concerning his address. Defendant has filed a motion to set aside the default judgment ECF number 19 and a motion to set aside default judgment revised ECF number 20. Both include an affidavit from defendant stating that he moved on July 15th, 2019 to an address in Charlotte. Hi, Puck. How you doing? You cannot have this cookie, but it will make you come over here. The puppy dog eyes for the cookie. Nope. Oop. It's an Oreo. You can have Oreos. It's my Oreo. I'll fight you for it. Boop. Okay, goodbye. Sorry, I'm eating right in my microphone. Munch, 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 munch. I just wanted to get Puck over here. I may need to go for half of a second just to let him do his business. Defendant had set a motion to set aside the default judgment ECF number 19 and a motion to set aside default judgment revised ECF number 20. Both include an affidavit from the defendant stating that he moved on July 15th, 2019 to an address in Charlotte, ECF number 19 at 9, ECF number 20 at 9. This is the only sworn evidence submitted by the defendant. The revised motion also includes several unsworn items of inadmissible hearsay. There are two documents titled Affidavit of Residence, purportedly signed by Susan or Suzanne. I don't know which one. Well, I'm assuming Susan because there's no N-E at the end. Susan Curtis and Benjamin Potts, stating that defendant has lived in Charlotte since July 16th of 2019, ECF number 20 at 16 to 17. Neither of these purported affidavits are notarized. Womp womp. Rodent, no last name for 2. Boops for puckers. Well, so many boops. Is this the part where Steve made a mockery of the court? Kyle said so I know it's here somewhere. Mr. Serious, I mock the court every day before breakfast. Are you having Cinnamon Toast Crunch for breakfast, or is it Burger King? Oh, I can't with the nonsense. Okay, defendant also attached a copy of purported rental agreement for the residence in Charlotte, ECF number 20 at 11 to 12, a credit card statement showing the Charlotte address, ID at 13 to 14, and a 1099 form showing the Charlotte address, ID at 15. Finally, defendant attached what he calls a transcript of a YouTube video. He includes, technically the truth. It's not a transcript of the original video, it's a transcript of a video that's been clipped to hell and back. So, which was then re-uploaded as a YouTube video, so technically the truth. And he includes a link to an obviously doctored 54-second snippet of that video. T at 10. None of the attachments to defendant's motion, even the unsworn statements and hearsay, provide any evidence that defendant failed to receive notice of the lawsuit. Right, so just because him not living there does not actually show that he didn't receive the documents. The 2 documents referenced are one-page affidavits by defendant bearing what appears to be the exact same notary date and stamp. However, the second one, ECF number 20 at 9, appears to be an altered version of the first affidavit. It apparently was altered to show that that delivery to the Providence Church Road address was on August 30th, 2019, which is the date listed on the return receipt. Argument. Motions to set aside are in the discretion of the trial court and will not be overturned except for abuse of discretion. Defendant asserts that the partial judgment by default should be set aside pursuant to Rule 60b-4 of the North Carolina Rules of Civil Procedure. Motions for relief under Rule 60b are within the sound discretion of the trial court and will not be overturned on appeal unless the trial court is found to have abused its discretion. Estate of Teal v. Darby, 129 NC App 604607. 1998. Under 60b-4, a judgment may be set aside when it is void. Defendant contends the judgment here is void because he was not properly served with the summons and complaint as set forth below. Service was proper and the judgment is not void. Uncovering Hypocrisy says, sometime check out Kyle's mom's signature on the filing and her signature on the UPS signature delivery form. Completely different. Another forgery from Kyle, I'm thinking. Maybe. I don't know. So we have a hearing date for this set for May 11th, where for Kyle to show why he's not in civil contempt, and it's for civil specifically. That doesn't mean, even if he complies then and Steve gets the show back, and let's say he happens to have all the stuff, like all the financials and all the accounts and everything, assuming he has that and is able to turn all of that over. That doesn't mean that it's over for Kyle. All that means is that Steve is done. Steve's got what Steve is supposed to be getting. There's still perjury on the court. There's still submitting falsified documentation. There's still the false copyright strikes, which are... there's more to this after the non sequitur show stuff is over. So I'm going to keep following this and seeing what happens, and I am curious if Kyle's mother will be called to give affidavits or get questioned or deposed or anything. I'm not sure. Service is presumed to be proper because plaintiff served defendant by certified mail and filed an affidavit as required by the North Carolina Rules of Civil Procedure. Under Rule 4J1A, the North Carolina Rules of Civil Procedure, a natural person such as defendant may be served by leaving copies of the summons and complaint at the defendant's dwelling or usual place of abode with some person of suitable age and discretion then residing herein. Service may also be obtained by mailing a copy of the summons and complaint, registered or certified mail, return receipt requested, addressed to the party to be served, and delivering to the addressee. NCRCP 4J1C. When service is obtained by certified mail, the plaintiff must file an affidavit stating that a copy of the summons and complaint were delivered to the post office for service by certified mail. Return receipt requested, that the copy was in fact received as evidenced by the return receipt, and attach the original copy of the return receipt, NC General Statute, paragraph 1 to 75.10A4. The affidavit raised the presumption set forth in Rule 4J2 that the person who received the mail or delivered and signed the receipt was an agent of the addressee authorized by appointment or by law to be served or to accept service of process, or was a person of suitable age and discretion residing in the address's dwelling, house, or usual place of abode. The presumption does not require the signature of the actual addressee. See e.g. Granville Med I don't know what CTR versus Tipton 160 North Carolina, App 484491 2003. The presumption arises upon proof of delivery regardless of the identity of the signer. Here, plaintiff served the summons and complaint on defendant by certified mail at the address defendant had regularly used. Plaintiff never received any mail showing that the address was incorrect, and defendant never took action to correct his address on the numerous items of correspondence sent to him at the address and by email. The summons and complaint were signed for by a person at the address. Plaintiff filed the required affidavit and attached the original return receipt. Under these facts, proper service on defendant is presumed. Defendant has actual notice of lawsuit and has failed to rebut the presumption of proper service. The presumption of service is rebuttable. To rebut the presumption, a defendant must present evidence that service of process failed to accomplish its goal of providing defendant with notice of the suit, rather than simply questioning the identity, role, or authority of the person who signed for delivery of the summons. ID at 493, citation omitted. Courts do not countenance gamesmanship by parties attempting to void legal process. ID internal quotation omitted. Here, the defendant has treated the lawsuit like a children's game rather than a serious effort to administer justice. Defendant has been sent multiple notices by mail and email starting in July of 2019 and has failed to respond to any of them. In the meantime, defendant has appeared in YouTube chats making it clear he was fully aware of this process. McRae Affidavit, paragraph 7. Oh no, did you? Do I need to go look at that? Rodent No Last Name says that he sent me a message on Twitter summing up Kyle's court filings. I'm gonna look at it. It's my live reaction. Sesame Street pratfalls. Ooh. Sorry, that's funny. I like that. This is good. Defendant apparently never McCrae Affidavit, paragraph 7. Defendant apparently never filed a... Okay, just a second. Defendant apparently never filed a change of address... Where did I... Hit? Hold on. Puck. Can you sit? Can you sit? Sit. Oh, good boy. Now wait, I'm just gonna finish this one and then we'll take a quick break and I will take you outside. Okay? Wait. Good boy. Okay. Defendant apparently never filed a change of address with the United States Post Office. Oh, what a good boy. Okay. Puck should never be ignored. As I ignore him. Excuse me. Defendant apparently never filed a change of address with the United States Post Office, and defendant does nothing in his affidavit to explain why documents served to the Providence Church Road address and signed for by a relative were not delivered to him. In fact, defendant's affidavit does not claim that he did not receive any notice of the lawsuit. He merely claims that it was served on a previous address, CID at 493-94, noting that defendant's attempt to rebut the presumption of service failed to allege that he did not receive the summons or notice of the lawsuit. Even the purported affidavit signed by Susan Curtis does not say that defendant did not receive notice, ECF number 20 at 16. To see the extent of defendant's gamesmanship, one need look no further than the snippet of YouTube that defendant linked, ECF number 20 at 10. We watched that yesterday, so if you're curious, go check that out. That small piece of video comes from a YouTube show that Mr. McCrae participated in on September 23, 2019, about 3 weeks after the summons and complaint were served. Mr. McCrae Affidavit 8. That podcast is over 2 hours long and covers a wide variety of topics, ID. Relevant here, the podcast discussed allegations by others that Mr. McCrae had doxed defendant by filing the summons and complaint with the business court, ID paragraph 9. Others had alleged that the defendant no longer lived at that address, ID paragraph 11. Mr. McCrae's take on the subject was that A, he had not doxed defendant by initiating a lawsuit and following the rules of civil procedure, and B, if the address was wrong as defendant claimed, it could not be doxing, ID paragraph 10. Shocking. It is obvious from this discussion that defendant knew about the complaint since he was aggravated at being doxed. Paragraph ID paragraph 9. Oh, that's a good point. If he was complaining that Steve doxed him, he knew that the lawsuit was going on because that's how he was saying that Steve doxed him. Oh no. Oh, God damn it. Instead, however, defendant did not respond by providing his correct address or acting to quash service of process. Instead, he ignored all correspondence sent to him and refused to appear until long after his default was entered. Such behavior is not rewarded by courts in North Carolina. See Granville Med CTR 160 NC app at 493 internal quotation omitted. Noting that courts should not put themselves in the position of failing to recognize what is apparent to everyone else. Conclusion. As stated above, plaintiff is entitled to the presumption of service and defendant has filed to rebut that presumption. Therefore, defendant Rule 60B, motion to set aside the judgment, should be denied. Respectfully submitted. This is the 12th day of February 2020. And then that. Certificate of service. The undersigned hereby certifies that a copy of the foregoing was served via email and United States mail, first class postage, prepaid, on the defendant, address as follows: Kyle Russell Curtis, 1532 Providence Church Road, Pleasant Garden, NC 27313, and 2435 Anna Garrison Road, Charlotte, North Carolina, 28263. Kyle Curtis, this is the 12th day of February 2020. Alright, Doggo needs to go outside. I'm just going to go on the be right back screen. It's going to say starting soon because I haven't changed any of that over and I don't care to. I will be back in a couple minutes. Excuse me. Alright, I'm back. Puck is happily outside right now. Backer BRB screen alone is gonna leave me penniless for years. Oh god, yeah, that's what it feels like. So, 22. Oh, what the hell? Oh. So here's the additional stuff in. So none of these have a little plus beside them, but this one does. Is 21 here, and it's all of the plaintiff's responses. So let's take a look and see what we got here. Exhibit A. Property summary. So here's the, oh god, I wish I could spin this. This is the document that, these are the exhibit A, B, C, da-da-da. These are the ones that are referenced inside of the motion. So that's why they're put together like this. So here's the location of address. This is the property summary, last updated 2019, 12/12. Tax year is 2020. Randolph County real property data. Location address 1532 Providence Church Road. Property owned Curtis Claude R. Curtis Suzanne L. Owner's mailing address 1532 Providence Church Road, Pleasant Garden, NC 27313. Property description, and then market area, Providence, planning jurisdiction, city, single family residence, land class, deed date 1990, deed book, page, package sale, sale price, total living area, total buildings 1, total appraised land, and that's the value of the land and the taxable stuff going on. So there's the how lovely, the mailing address and the owners of the address. Exhibit B. What do we got here? Hey, it's not sideways. Thanks. Business practice via email. Connors Morgan, business practice, Revolution Mill Drive, Greensboro, North Carolina. Some email, blah, 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 blah. July 17th, 2019, via email and U.S. mail, Kyle Russell Curtis, 1532 Providence Church Road, Pleasant Garden, NC 27313. Emails to Kyle and to the Non Sequitur Show email. Mr. Curtis, please, Mr. Stephen McRae. Mr. Curtis, please be advised that this firm represents Mr. Stephen McRae, Mr. McRae, in regards to his entitlement to certain funds derived from operations of the podcast and YouTube channel, The Non Sequitur Show. In or around December of 2017, you and Mr. McRae created and began airing podcast episodes of The Non Sequitur Show. You and Mr. McRae entered into a business relationship and agreed that you would both appear on the show as co-hosts, would have equal decision-making power in regards to the show's operating and airing, and would divide any potential profit equally. After several dozen relatively successful episodes, Mr. McRae approached you about expanding your entrepreneurial endeavors to encompass a YouTube channel. After receiving positive feedback from you, Mr. McRae created the account and by default obtained primary ownership of the channel. Over the channel. Shortly thereafter, you encouraged Mr. McRae to surrender primary ownership of the channel, representing to him that administrative powers by you was necessary in order to establish search engine optimization. Mr. McRae genuinely believed and relied upon your representation and subsequently made you the primary account holder. At or around the time of the formation of the channel, Mr. McRae began experiencing medical issues. In anticipation for surgery, Mr. McRae continued to participate on the talk show. However, he requested that no proceeds from the show be distributed to him at that time. Not long thereafter, the Non Sequitur Show began profiting significant revenue, and Mr. McRae was ready to receive his distribution. At that time, you refused to provide half of the show's proceeds to Mr. McRae and therefore refused to distribute the financial statements memorializing the channel's financial position in violation of NC General Statute paragraph 59 to 49 and 59 to 50. It is understood that the Non Sequitur Show has potential revenue streams including but not limited to advertising payouts, super chat, Streamlabs, merchandise sales, and even donations in several forms which are made by subscribers. It is apparent that the Non Sequitur Show has produced substantial earnings through these methods as well as others, and the expenses of the channel are few and far between. Being that the channel was not monetized until around July of 2018, you asked Mr. McRae to patiently wait until April of 2019 to be paid so you could handle the channel's taxes. When Mr. McRae approached you on April 15th, 2019 to inquire about the money he is owed, you mentioned that your accountant would contact him. You refused to disclose the identity of this person, in fact, this person never contacted with Mr. McRae. After multiple other attempts to collect his share of the channel's proceeds, you informed him of your unlawful intent to retain the entirety of the earnings from Teespring and other revenue streams, and added that you ran the show. On June 11th, 2019, you participated in a pre-show in anticipation for a live show, which was ultimately posted to YouTube as The Death of the Non Sequitur Show. We covered this in our Prelude prequel thing. Yup. Oh, they have a rotating interface? Thank you. I will do that for the next one. Your behavior clearly exhibited an intent to change the direction of the channel and to strip Mr. McRae of his partnership rights in the business operations. His transfer of primary admin responsibilities was based on a good faith belief that you could increase traffic on the channel. Instead, you misrepresented this fact in order to maintain sole control of the channel for the channel and to force Mr. McRae out of the Non Sequitur Show's affairs. These misrepresentations constitute fraudulence and will not be tolerated. Furthermore, you have falsely accused Mr. McRae of tax evasion and insurance fraud, using this as your basis for not distributing his portion of the earnings. So yes, during this time, Kyle and Katie and Casey, a handful of the people that were listed in that lawsuit, tried to say that Steve was avoiding taxes and saying that he was a part of fraud of the VA. So that's they kind of just tried to smear him away to detract from their own current fraud and collusion. It was nice of Kyle to list all those people in the... He missed one of them. But hey, whatever. Mr. McRae's primary insurance fraud, using this as your basis for not distributing his portion of the earnings. Mr. McRae's primary insurance derives from Veteran Affairs benefits and is not contingent on income whatsoever. Your allegations are unfounded, and the dissemination of the same constitutes defamation per se, a finding which carries the potential of treble damages, which we know Steve was awarded treble damages. Mr. McRae's medical affairs and insurance coverage are irrelevant to the business arrangement regarding the Non Sequitur Show and will not be accepted as a basis for failure to distribute the money he is entitled to. Therefore, on behalf of Mr. McRae, we demand the following. This is the demand letter, by the way. This was filed before... this was sent to Kyle before the lawsuit was actually brought forward. Therefore, on behalf of Mr. McRae, we demand the following. You submit to a litigation hold preserving all data that may relate to this matter, including but not limited to existing videos posted by or regarding the Non Sequitur Show, financial documents pertaining to the Non Sequitur Show's financial status, and communication between you and any other person regarding the Non Sequitur Show or Mr. McRae. You refrain from posting videos on behalf of the Non Sequitur Show, an immediate surrender of all records and notices pertaining to the Non Sequitur Show's income, expenses, taxes, or otherwise financial status pursuant to North Carolina General Statute, paragraph 59 to 52, restitution amounting to 50% of the non sequitur show's net income and value up until June 11th, the monetary amount to be determined following Mr. McCrae's review of the aforementioned financial statements. 5. Return of the primary administrative account ownership with primary authority to Mr. McCrae of the Non Sequitur YouTube channel as it was attained by you in bad faith and pursuant to fraudulence. Mr. McCrae would like to settle this matter without having to take legal action, but is prepared to take those steps to obtain relief. Please respond to this letter within the next 7 business days. If you have any questions or concerns, please contact me via email or by telephone at telephone. All the best, Steve's lawyer. Exhibit C. So as you can see, Kyle did absolutely nothing to try and settle this matter outside of court. Steve's lawyer, August 29th, 2019, via email and priority mail, Kyle R. Curtis, 1532 Providence Church Road, Pleasant Garden, North Carolina, 27313, emails. Re McCrae versus Curtis, pre-litigation notice to preserve data. Mr. Curtis, as you may be aware, we represent Mr. Stephen McCrae in the pending legal action against you, file number 19CVS8163. This letter is not to put you on notice of your obligations to keep and preserve. This letter is to put you on notice of your obligation to keep and preserve all documents and electronically stored information that is potentially relevant to Mr. McCrae's claim. Please be advised that we believe electronically stored information will be an important and irreplaceable source of discovery and/or evidence in this matter. You are required to preserve all information from your computer systems, removable electronic data, and other locations. The Twitter and Discord. Any of that stuff. This includes, but is not limited to, email and other electronic communication, word processing documents, spreadsheets, databases, calendars, telephone logs, internet usage, files, network access information, and specifically the contents of the Non Sequitur YouTube channel and podcast at the heart of this dispute. That actually includes all of the Non Sequitur and all its assets, includes all of the thumbnails and all of that stuff. Whew. You should also preserve the following: databases, networks, computer systems, including legacy systems, hardware and software, servers, archives, backup or disaster recovery systems, tapes, disks, drives, cartridges, and other storage media, laptops, personal computers, internet data, personal digital assistant, handheld wireless devices, mobile telephones, paging devices, and audio systems, including voicemail. All of the information should be preserved for the following dates and times period: December 1st, 2017 through present. McCrae vs. Curtis, August 29th, 2019, page 2. Preservation of obligations. The laws and rules prohibiting destruction of evidence apply to electronically stored information in the same manner that they apply to other evidence. Due to its format, electronic information is easily deleted, modified, or corrupted. Modified. Accordingly, you must take every reasonable step to preserve this information until the financial resolution of this matter. This includes, but is not until the final, not financial, sorry. Accordingly, you must take every reasonable step to preserve this information until the final resolution of this matter. This includes, but is not limited to, an obligation to disclose all data, destruction, and backup tapes, recycling policies, preserve the contents of the existing Non Sequitur YouTube channel, including but not limited to all videos, comments, and and other material associated with the channel, preserve and not dispose of relevant hardware unless an exact replica of the file, a mirror image, is made. Maintain all other pertinent information and tools needed to access, review, and reconstruct necessary to access, view, and or reconstruct all requested or potentially relevant electronic data. Description of data sought. This matter requires preservation of all information from your computer systems, removable electronic media, and other locations relating to the Non Sequitur Show and Mr. McRae. This includes, but is not limited to, email and other electronic communications, word processing documents, spreadsheets, databases, calendars, telephone logs, contact manager information, internet usage files, network access information, and specifically the contents of the Non Sequitur YouTube channel and podcast. Electronic files. You have an obligation to preserve all digital or analog electronic files in electronic format, regardless of whether hard copies of that information exists. This includes preserving active data, archive data, deleted data, and legacy data. Hardware. You have an obligation to preserve all electronic processing systems, even if they are replaced. This includes computer servers, standalone personal computers, hard drives, laptops, PDAs, and other electronic processing devices. Basically, if he gets a new phone, he has to still have his old phone. Emails. You have an obligation to preserve all potentially relevant emails that were sent or received. Email must be preserved in electronic format, regardless of whether hard copies of information exist. Internet web activity. You have an obligation to preserve all records of internet and web browser generated files in electronic format, regardless of whether hard copies of the information exist. This includes internet and web browser generated history files, caches, and cookies files stored on backup media or generated employees of you. Mr. McRae versus Curtis, August 29th, 2019, page 3. Other relevant information. You should preserve all documents and data relating to computer systems, programs, software, hardware, materials, tools, or information concerning the Non Sequitur Show or Mr. McRae, including without limitation all changes, modifications, versions, and evidence that the documents of disseminated and to whom. So basically that's any kind of messaging. So we know that Kyle was talking to Katie Joy when this all initially went down, because Katie told us, and she did, to her credit, she read off her text messages with Kyle, and she said that Kyle's the one who told her that Steve was committing medical fraud or VA fraud or whatever, 7 other things that she said. So that means all that information, all those conversations need to be saved via this, right? If the conversation was on Twitter, it needs to be there. Any conversation he had with anybody about Non Sequitur or about Steve on either using Twitter, either his personal one or the Non Sequitur one, which he then changed the name of. Any conversation he's had on Discord, any conversations he's had on any of his phones. If he was talking to somebody on Grindr about how he ran Non Sequitur, then that would count. Any of that stuff. Other relevant information. You should preserve all documents and data relating to computer system, program, software, hardware, materials. I read that one already. Preservation compliance. Activity log. In order to show preservation compliance, you must maintain a log documenting all alterations or deletions made to any electronic data storage device or any electronic data processing system. Mirror images. You must secure a mirror image copy, a bit-by-bit copy of a hard drive that ensures the computer system is not altered during the imaging process. Of all electronic data contained on your personal computer, the mirror image should include active files, deleted file fragments, hidden files, directories, and any other data contained on the computer. You must also collect and store any offline or online storage devices that contain data from any electronic processing device containing information about or concerning Mr. McRae. Chain of custody. For all the data preserved, you must document a complete chain of custody. A proper chain of custody will ensure that no material changes, alterations, or modifications were made while the evidence was handled. Chain of custody documents must indicate where the data has been, whose possession it has been in, and the reason for that possession. So basically, if he handed the channel off to somebody else, let's say, or if he handed the Discord, like he said in his letter, off to somebody else, or somebody else had it from him, that chain needs to be, he needs to be able to show that chain and why. And everything still has to be maintained even after that person has it. Electronic data created after this letter. For any electronic data created after this letter, for any electronic processing systems used after this letter, you must take the proper steps to avoid destroying potentially relevant evidence. This includes, without limitation, following the above preservation protocols. Your compliance with its preservation obligations includes forwarding a copy of this letter to all individuals or organizations that are responsible for any of the items referred in this letter. If this correspondence is in any respect unclear, please call me immediately. Your compliance with this preservation obligation includes forwarding a copy of this letter to all individuals or organizations that are responsible for any of the items referred into in this letter. That's crazy. 1 second, I need to go yell at my dog. He's being barky. 1 moment. Oh, that's what his problem is. School's back in, and there are children that I back onto a school. The backyard there's a schoolyard, and so the kids like to come and like sit out on the fence, like right at the fence, and yell at him. Not in a bad way. They're not like taunting my dog. They're just like, "Oh, look, a puppy!" And it's adorable. And so they're yelling, and Puck is yelling, and everybody's yelling, and they're all having a grand old time. Sing my song above, please. What's the in sing song of what? Oh, Kyle and KJ defaming in a tree, snorting Addie like little queens. First comes lines, second comes defamation, third comes some lawsuits they can't get away from. I don't know if I sung it right. Womp womp. Exhibit D. Certified mail. Blah, 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 blah. Steve's lawyers. I should say Steve, the firm, but whatever. Certified mail and electronic mail. January 27th, 2020. Kyle R. Curtis, 1532 Providence Church Road, Pleasant Garden, North Carolina, 27313. Email. Steve McRae versus Kyle Russell Curtis, 19 CVS 8163. Mr. Curtis, enclosed, please find a copy of the entry of partial judgment by default, which was entered on January 23rd, 2020. Per the terms of the judgment, you are required to return administrative control and primary ownership rights of the Non Sequitur podcast YouTube channel and other accounts associated with your partnership with Stephen McRae. Therefore, pursuant to the judgment, we demand that you provide the following. 1. All necessary credentials and passwords for the Non Sequitur Show website. 2. The username and passwords to access the Non Sequitur Show YouTube channel. 3. The username and passwords to access the Non Sequitur Show Patreon account. 4. The username and passwords to access the Non Sequitur Teespring.com account. 5. The username and password to access the Non Sequitur Twitter account. 6. The username and password to access the Non Sequitur Show subreddit account. There's a subreddit account? Did I know about that? I feel like I probably knew about that, and then it just left my brain. 7. The license for the vMix software, and 8. All necessary credentials and passwords to access all podcasting services where the Non Sequitur Show is accessible: iTunes, Google Play, Spotify, iHeartRadio, SoundCloud, etc. These should be provided to me immediately, either by email or by facsimile, along with any other information necessary to assume control of these accounts. If there are other accounts related to Non Sequitur Show, please provide the information about those as well. For example, the Streamlabs and Facebook accounts also need to be transferred to Mr. McRae. January 27th, 2020. In addition, the judgment requires you to provide access to all financial documents associated with the Non Sequitur Show within 14 days of the date of the order. These documents should be delivered to my office at the address above. Delivered to my office. Not put in a fucking letter to the court, put out to the public, you dumbass. Ugh. The term document includes both paper documents in your possession or control, as well as electronic documents such as emails, PDFs, MS Word files, etc. Please let me know when you intend to produce these documents so that we can make sure someone is in the office to receive them. Sincerely, Steve's lawyer. State of North Carolina, Guilford County, Stephen McCrae plaintiff versus Kyle Russell Curtis, defendant in the General Court of Justice, Superior Court Division, 19 CVS 8163, entry of default judgment. And here's we read this default judgment already. This is just Steve's lawyer sending all of the information to Kyle again. So that's what that is. We've actually read through all this already. So if you wanted to see the default judgment, we read that yesterday. Oh, sorry, no, not yesterday. We read that the day before. That's part 2. All right, affidavit. Let's minimize this again. We're on 22. Whoop. Affidavit. North Carolina, Guilford County, Stephen McCrae. So this is the affidavit that's referenced in the one we were reading. So when it said affidavit Steve McCrae, paragraph 7 or whatever, this is the affidavit that is referring to, because all these are submitted at the same time. North Carolina, Guilford County, Stephen McCrae, plaintiff versus Kyle Russell Curtis, defendant. In the General Court of Justice, Superior Court Division, 19 CVS 8163, affidavit of Stephen McCrae. I, Stephen McCrae, being duly sworn, state as follows. 1, I am over the age of 18 and am competent to make this affidavit. 2, I am submitting this affidavit in support of my response to defendant's motion to set aside entry of default and motion to show cause. Defendant's motion to set aside default judgment. 3, without my dealings with Mr. Curtis, he represented to me that he lived in North Carolina and that his address was 1532 Providence Church Road, Pleasant Garden, North Carolina, 27313. I understood that he lived at this address with his parents. Documents prepared by Mr. Curtis listed this address. For example, around the time we were forming non-sequitur, Mr. Curtis prepared a fictitious business name statement for filing in North Carolina that listed his address as 1532 Providence Church Road. A true and accurate copy of the document prepared by Mr. McCrae is attached as tab 1. 5. In email correspondence concerning the non-sequitur show, Mr. Curtis's signature blocked listed his address as 1532 Providence Church Road. A true and accurate copy of the documents prepared by Mr. Curtis is attached at tab 2. At no time prior to the filing of this lawsuit and service of summons and complaint on August 30th, 2019, did Mr. McCrae or anyone else tell me that Mr. Curtis had moved from the 1532 Providence Church Road address. After the address was served, Mr. Curtis participated in various internet venues or correspondence in which he acknowledged that the lawsuit had been filed and that he had notice of it. For example, on October 6, 2019, Mr. Curtis participated in a chat through a service called Discord, where he discussed the lawsuit, acknowledged that he had missed the filing deadline for 30, and acknowledged that he had been served 1600. Much of the discussion, which lasts for over 2.5 hours, deals with the allegations in the lawsuit. The audio file can be found at the following link. In a YouTube, I'm not watching a 2-hour nonsense of this. I played this yesterday. In a YouTube interview that also discussed the case, Mr. Curtis acknowledged that he did not appear in court and that he lied about having an attorney. 1 hour, 10 minutes, 47 seconds. The video can be found at the following link. Do you guys want me to give you guys the links? I don't know. I can't even copy paste this. Why? Okay, you guys, I'll leave it here. You guys can type it in if you guys want to type this in. You're on your own. In his revised motion to set aside default, Mr. Curtis included a link to an edited 54-second video of me, ECF number 20 at 10. We watched that yesterday. The full interview, where the short snippets is taken, occurred on September 23rd, 2019, and can be found at the following link. The interview is over 2 hours long and covers a range of topics, including this lawsuit. The snippet offered by Mr. Curtis starts at about 55 minutes into the interview. The interviewer and I discussed the fact that Mr. Curtis, copy it manually. Type that in. Do it. The interviewer and I discussed the fact that Mr. Curtis and others on his behalf were alleging that I had doxed Mr. Curtis by including his address in the summons, which was filed with the North Carolina Business Court. Meanwhile, we listened to 8 hours of nonsense by you and Joe from Answers and Reasons. Yo, we were on stream for so long just talking about every single thing you could possibly think. What a fantastic conversation that was. But, you know, it was long. I agree with that. I don't expect people to watch that. The only people I expect to watch that are people who are, like, looking for something to take out of context to make it sound like I sound like an awful human being. But, you know, whatever. I'm not a human anyway. I'm a goblin. I had 2 basic rejoinders to the allegation that I had doxed Mr. Curtis. First, the summons was a public document filed with the court, and second, the address was supposedly incorrect anyway. The reason I had stated in the interview that the address was wrong is that other people told me after the filing became public that Mr. Curtis had moved, which you can actually hear that in the clip. He's talking about other people, and he's talking about past tense. Other people knew, meaning he didn't know. I was never given any new address and never had any direct evidence as to whether he had moved or not. Defendant's failure to comply with a partial judgment by default. As of the... Puck, what are you yelling about? Children. I should probably go bring him in. Excuse me. I'm going to go get him. Puck is being a chore today, but you know what? I'm not going to complain. I love him, and it is very nice outside. According to Sir Sick, I'm a terrible human. Oh, you get to talk to Sir Sick? I don't get to talk to... I've only corresponded with Sir Sick like once or twice. I love his videos. He's fantastic. So if you guys haven't checked out Sir Sick, you should absolutely go check out Sir Sick. I really hope he comes on with us sometime. I would be so happy. Are we taking bets if Kyle shows for the last hearing? If so, what are the odds? Okay, my personal opinion, I think that he's going to show up because I think he might think that he'll be able to convince the judge, and he'll try to make arguments about, like, the same as his letter, if that makes sense. And he's going to try and... change the judge's mind about the case when it's not, and then he's just going to get shut down by the judge because that's not what the hearing is about. So That's what I would guess. That's kind of where my expectation is, but I am really holding out hope for tickets to Mexico. I'm holding out. Alright. Defendant's failure to comply with the partial judgment by default. As of the date of this affidavit, Mr. Curtis has not turned over any of the accounts associated with our business endeavor as required by the judgment ECF number 17. He listed the supposed passwords to some accounts in his response ECF number 18, but none of them were correct. Also, as of April 23rd, 2021, as of this date, currently, Kyle Curtis has not turned over any of the accounts associated with their business endeavor, as required by the judgment ECF number 17. Just saying. Invite him. I have invited him. Although he is going to get invited. He'll get an invite to Non-Sequitur as well when we're going again. So I haven't spoken to him in a while. That'd be so cool. Mr. Curtis has not turned over the primary ownership of the YouTube channel. Mr. Curtis claimed he cannot turn over access to the Discord server because he did not create it. I know that he did create it. Mr. Curtis did not turn over the Non-Sequitur Twitter account and has apparently deleted it entirely. As of now, it just changed to Audionaut. He just changed the @ so there's that going on. Mr. Curtis Mr. Curtis did not turn over the non-sequitur, blah, blah, blah. Mr. Curtis has not provided any financial documents other than the unsupported summaries in his submission of ECF number 18. That's a nice way of calling that. Mr. Curtis and I, I didn't do this fraud. I was busy doing this fraud over here. Embezzlement. Mr. Curtis and I never agreed that he would invoice the show for his work. He never showed me an invoice and never told me he was doing work outside of the scope of the business for which he thought he should be paid. We had no agreement for him to pay himself without my input and approval. Business for which he thought he should be paid, we had no agreement for him to pay himself without my input or approval. Further, the affiant saith not. The 12th day of January 2020. Blah, 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 blah. Notary. Hey, you think that maybe Kyle's just trying to drag things out until the notary expires? Except that notary doesn't actually expire, it's just the commission. It's 2023. Alright. Wait, that was all of that, right? I didn't, click off of that too early, did I? Oh, I did click off of that too early. Okay. Wells Fargo. Notary. This is the stamp of notary for Steve's affidavit, so his affidavit was notarized. Certificate of service. The undersigned hereby certifies that a copy of the foregoing was served via mail, United States mail, first class, postage prepaid on the defendant. Address as follows: Kyle Russell Curtis, 1532 Providence Church Road, Pleasant Garden, North Carolina 27313, and 2435 Anna Garrison Road, Charlotte, North Carolina 28263, and 2 emails. This is the 12th day of February 2020. All of this stuff was getting emailed to Kyle the whole time, and mailed to Kyle the whole time. God dang. Can I just point out how savage Steve's lawyer is? Okay, so here's tab 1 and tab 2 that were referenced. Tab 1. Fictitious business name statement. Your return mailing address. Name, Kyle Russell Curtis. Address, 1532 Providence Church Road, City, Pleasant Garden, State, California, zip code 27313. Bro! Come on, man! God damn it, dude. Non-sequitur media, following or doing business. This is Los Angeles, so this is California. the California information. Here's the 1532 Providence Church Road for mailing address, because it's different. So this was put in as the mailing address. Registered owners, Kyle Russell Curtis. Residence address, 1532 Providence Church Road, Pleasant Garden, California, 27313. Then this should actually, he filled this one wrong because he said if corporation and state. Yeah, okay, so this is the if corporation or LLC print state of corporation, so that's where they were planning on doing taxes and stuff, because Steve was in California, it looks like. Steve, address Sun City, which is, I don't know if that's supposed to be, whatever. This is some Steve stuff. Steve, Kyle, general partnership. Registered corporation, Kyle Curtis, title partner. Kyle Curtis, non sequitur me, affidavit of identity. If submitted, the fictitious business names statement by mail or through a third party, the register must bring this page to a notary to be notarized. Registrant name, Kyle Russell Curtis, name of business, non sequitur media. What a crummy name. I don't like that. Address, 1532 Providence Church Road, Pleasant Garden, Why did you put California? 27313. I don't think Kyle knows how to file paperwork properly. Good thing this was just a practice filing. Let's look at tab 2. Boop. What do we got in here? Tab 2. Kyle Curtis, host, The Non Sequitur Show. Phone number, live, nonsequitur.com. Skype, Kyle Curtis, 1532 Providence Church Road, Pleasant Garden, North Carolina, 27312. On July 21st, 2018 at 9:13 p.m., Kyle Curtis, Gmail, wrote, forwarded a message from, oh, it looks like Modern Day Debates. This is from James. Hi, James. Look at you showing up in here. Oh, well, I'm not going to read this because it didn't really matter. It's just an example with this. Ah, that's so awkward. Other motion. North Carolina, Guilford County State. Guilford County, Stephen McRae, plaintiff versus Kyle Russell Curtis, defendant in the General Court of Justice, Superior Court Division, 19 CVS 8163. Plaintiff motion for order to show cause. Plaintiff Stephen McRae, through his undersigned counsel and pursuant to North Carolina General Statute, paragraph 5A-323AL, submits this motion for order to show cause, requesting that the court order defendant to appear before the court and show cause as to whether he should be held in civil contempt for failure to comply with the court's entry of partial judgment by default. In support hereof, plaintiff relies on the affidavit of Stephen McRae filed contemporaneously herewith and shows the court as following. On January 23rd, 2020, the court entered the entry of partial default judgment by default, ECF number 17, herein after the judgment. The judgment required defendant to return administrative control and primary ownership rights of the Non Sequitur podcast YouTube channel and all other accounts associated with the party's business endeavor to plaintiff. Oh, California is GA, not CA? What's CA then? That makes no sense. What's CA? California is GA? What is CA then? I'm Canadian. I know none of this. The judgment required defendant to return administrative control. I just read that. The judgment further required defendant to provide plaintiff with all financial documents associated with Non Sequitur's financial affairs and financial condition within 14 days of the date of that order. On February 4th, 2020, defendant submitted a document he titled Compliance to Order, ECF number 18. And this document is signed on the first page but is not notarized. Defendant's submission in no way complies with the court order and in certain ways directly disregards disregards it. For example, defendant does not turn over the Non-Sequitur Show Twitter account as required by the judgment, but instead states that he intends to delete it, ECF number 18 at 7. It appears that defendant actually has deleted the Twitter account, thereby destroying evidence and an account owned by the business, Mr. McRae, Affidavit 15. Defendant refuses to turn over access to the Non-Sequitur Discord server, claiming that it is not administrated by him, ECF number 18 at 7. That is incorrect, McRae, Affidavit 14. GA is Georgia. I'm so confused. Defendant has not turned over ownership to the YouTube channel, McRae Affidavit 13. Defendant states that he intends to retain 50-50 ownership in direct conflict with the court's order, ECF number 18 at 7. Defendant further states that he would provide a screenshot showing that the link had been provided, ID. No such screenshot has been produced. Defendant provided a list of usernames and passwords for several other accounts, ECF number 18 at 7. None of them were correct. McRae Affidavit, paragraph 12. Defendant failed to provide any financial documents, but simply listed unsupported hearsay summaries, ECF number 18 at 2, 16, 17 to 20, 22 to 23, McRae Affidavit 16. Moreover, defendant's submission shows the extent of his fraud and malfeasance. He states that the business took in $49,158.72 for revenue in 2017 through 2020, ECF number 18 at 16. He then lists operating expenses of $69,069 and $10.66, consisting almost solely of non-existent invoices from himself. I had to charge myself to pay myself so my business would be in the red so I don't have to pay Steve. You know, all of this could have just not was an option, if you recall. If you watch the prequel thing that I did, whenever I did that, watching the Death of the Non-Sequitur Show, just not was an option. And you saw that we read the emails and letters that Steve's lawyer sent to Kyle before a lawsuit was actually brought forward. Malfeasance, thank you. He could have just not. He could have so easily just not. But no, here we are. ECF number 18 at 16 to 20. Here we are in the year of our Lord 2021, April, waiting for May 11th of 2021 for this thing that was done last year sometime. None of these supposed invoiced are attached to the defendant's submission. Defendant never submitted invoices to Mr. McRae, and there was never an agreement to pay defendant for his supposed services. McRae, Affidavit, paragraph 17. Defendant states that despite earning $49,158.72 in revenues, the business has zero cash in the bank, showing that he has used the revenues to fraudulently pay himself. ECF number 18 at 20. Bad move, Kyle, buddy. Not your buddy, guy. Wherefore, for the reasons set forth above, plaintiff requests that the court find that there is probable cause that defendant has violated the judgment and order him to show cause as to why he should not be held in civil contempt unless and until he complies with the judgment. Respectfully submitted this 12th day of February 2020. It's been a year since they first were like, hey, contempt though? It's been over a year. Certification of service. Hey, all this was sent to Kyle this day. Oh no. Alright, we got two more from Steve's lawyer before the court responds, so let's take a look. Hey! North Carolina, Guilford County, Stephen McRae, plaintiff versus Kyle Russell Curtis, defendant in the General Court of Justice, Superior Court, 19 CVS 8163. Brief in support of plaintiff's motion for order to show cause. Plaintiff Stephen McRae, through his undersigned counsel and pursuant to North Carolina General Statute, paragraph 5A-23AL, submits this brief in support of motion to order of show cause, requesting that the court order defendant to appear before court and show cause as to whether he should be held in civil contempt for failure to comply with the court's entry of partial judgment by default. Pursuant to North Carolina General Statute, paragraph 5A-21A, a person may be held in civil contempt when 4 conditions are met. 1. The order violated remains in force. 2. The purpose of the order may still be served if the alleged contemptor complies with the order. 3. The alleged contemptor violation of the order is willful, and 4. The alleged contemnor, God, that's a hard word to say, is able to comply with the order. Proceedings for civil contempt may be commenced, quote, by the order of a judicial official directing the alleged contemptor to appear at a specific reasonable time and show to show cause why he should not be held in civil contempt, end quote. NC General Statute, paragraph 5A-23A. Such order may be issued on the affidavit of one with an interest in enforcing the order and finding by the presiding judicial official that there is probable cause to believe the alleged contemptor should be held in contempt. Contemptor. Listen, words. Words and shit. IDCEG Shoemaker versus Schumacher. 137 NC App 7276 2000. Once it is determined that probable cause exists, the burden shifts to the alleged contemptor to show that he should not be held in contempt, that he lacks the means to comply, or that his noncompliance was not willful. ID. Here, plaintiff relies on a sworn affidavit of Stephen McRae, filed contemporaneously herewithin to show probable cause to hold defendant in contempt. McRae affidavit paragraph 12 to 17. As shown in the affidavit, Mr. Curtis has failed and refused to comply with the partial judgment by default, ECF number 17. Moreover, he has openly defied the judgment by willfully deleting the Non-Sequitur Show Twitter account. McRae affidavit paragraph 15. Finally, defendant submitted documents to the court showing that all the revenues earned by Non-Sequitur Show are missing, presumably showing the defendant willfully absconded with the funds. ECF number 18 at 20. I've never seen somebody write a letter to the court being like, look all the crime I did. Look at me complying by showing you all this crime. Wherefore, not that I look at a whole ton of lawsuits, but dude. Wherefore, for the reasons set forth above, plaintiff requests that the court find that there is probable cause that defendant has violated the judgment and order him to show cause as to why he should not be held in civil contempt unless and until he complies with the judgment. Respectfully submitted on this 12th day of February 2020. Certificate of service. This was sent to Kyle. I'm not going to read this every time. It's just getting sent to both. You guys can see it. Oh, God. Savage, this man. Affidavit. Boom. North Carolina, Guilford County, Stephen McRae, plaintiff versus Kyle Russell Curtis, defendant in the General Justice, Superior Court, Court Division 19, CVS 8163, Supplemental Affidavit of Stephen McRae. I, Stephen McRae, being duly sworn, state as follows. I am over the age of 18 and am competent to make this affidavit. I previously submitted an affidavit in support of my opposition to defendant's motion to set aside default judgment, and in my support of my motion for order to show cause, ECF number 22. This affidavit supplements that affidavit. Mr. Curtis is still the only one with access to the channel. As of the date of this affidavit, Mr. Curtis continues to defy the partial judgment by default and is still not turned over any of the following: primary ownership of the YouTube channel, access to the Discord server, the non-sequitur Twitter account, or any financial documents other than the unsupported summaries in the submission of ECF number 18. He still hasn't. Mr. Curtis has done things and threatened to do things in direct violation of partial judgment by default in ECF number 17. Mr. Curtis has renamed the Non-Sequitur Show Twitter account, formerly Non-Sequitur Show at Non-Sequitur Show, now named Audionaut, and started using the account as his own. Effectively, he has stolen the account and over 5,000 followers of the Non-Sequitur channel. Upon information and belief, he had an associate register with Twitter under the old Twitter name. Okay, so upon information and belief, he had an associate register the Twitter under an old Twitter name. So this is when he deleted the Twitter, brought it back, changed the name to changed the handle at the same time as somebody else grabbed the handle who we know he was talking to at the time. So there's belief that there may be collusion there. They're working together. A printout of the Twitter showing the new name is attached as Exhibit A. Mr. Curtis posted on the channel community page about this case and included false and defamatory statements about me. A printout of the post is attached as Exhibit B. This was not allowed during the case. Another YouTube channel host who has been critical of Mr. McRae and favorable to Mr. Curtis has posted that he and Mr. Curtis intend to do a live stream from the Non-Sequitur Show channel in the very near future. It didn't happen, but still not allowed. A copy of the post about the live stream is attached as Exhibit C. The longer I am denied access to the channel and related accounts, the more the channel is devalued. I have accepted to obtain access to and control over the channel by contacting YouTube directly and providing a copy of the court's partial entry of default. However, YouTube has refused to provide me access because the order does not specifically order it to do anything. A copy of the response I received from YouTube is attached as Exhibit D. Whisper the rest of the stream? I could do that. That was Anti-Ordinary, Demi, who had the Non-Sequitur Twitter app. Further, the affidavit saith not, and then there's the notary. Here's the rest of the notary. So this affidavit was notarized. Certificate of service. Exhibit A, Audionaut. Music is the only language you can't lie in. Thanks, Kyle. Charlotte, North Carolina. There's the SoundCloud. Followers, tweets are protected. Exhibit B, the Non-Sequitur Show 3 hours ago. At first I thought the outbreak was the reason we still don't have a ruling. Well, there was a ruling, so that's not true. Now I think it's because the judge looks at our e-file each day and says, let's see what fucking crazy bullshit is going on today. And then it's got the screenshot with all kinds of stuff. That's me! Oh, look, it's me. Exhibit C, Unirock. Just talked to Kyle. Will be streaming on Non-Sequitur channel coming up soon. Keep an eye out. Unirock and Kyle Curtis on Non-Sec this weekend. Confirmed with Kyle. Could we please get Jigglypuffs in the chat? Thank you. I'm dead. I can't. I wonder why that never happened. Oh, I wonder why that never happened. If anybody's still talks to, oh, hey, you know who does still talk to Uni as a wrench over his channel? Team Skeptic. Hey, Team Skeptic, can you do it? I accept your apology. Could you do me a favor and ask your buddy Unirock why he never showed up on the Stolen Non Sequitur Show channel? Because apparently he was going to. Do me a favor, let me know. Thanks, bud. Send me a DM. Oh, this hurts. Oh. I forgot about that stuff. Oh. Oh, this has been the best part of the retrospective so far. Exhibit D. Hi, Steve. Unfortunately, we cannot transfer the channel ownership to you. Steve, the court order clearly states that they are mandating Mr. Kyle R. Curtis, not YouTube. Let me know if you have any other questions. Google, YouTube, blah, 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 blah. We value your feedback. Yeah, whatever. Thanks, YouTube. Oh, God. And that was it. Oh, what a good thing to end on. That was perfect. I'm so happy. What a wonderful thing to fucking end on. Oh, God. Next up, we will see what the court had to say about that situation that was presented to them. Don't forget to like and subscribe, share the video, become a member if you're interested, join the Patreon if you're interested. There's discussions going on Discord over there if you're interested in those, becoming a member or a Patreon. Sometimes we do hangouts in there talking about this kind of stuff and giggling away and all that kind of nonsense. Let me know what you think in the comments down below. There won't be one of these tomorrow because tomorrow we have a pretty big stream over on the Creepy Readings channel with me and Steve and Red's Rhetoric. We'll be talking about this situation. So if you guys are interested, please, please, please go check that out. I'm sure it will be fantastic and a grand old time. So because that's happening, I won't be here doing this. Sunday also will not. Monday is going to be Judgment Call, so if you do have any questions or want to talk about anything about this that happens here or anything that happens over on the Creepy Reading, please feel free to give us a call on our call-in show, which will be on Monday, called Judgment Call at 2 p.m. Eastern, and then we'll be back with more of this on Tuesday. Play the video as the outro. Got it. On it. I'm opening it right now. It's happening. You're gonna screw me. I hope you're aware of this. You're gonna screw me, but I don't care. It's going up. It's going up. Here we go. See you guys next time. Bye.
One wedding cake. Two chocolate cream pies. Three birthday cakes. 4 root beer floats. 5 fancy fruitcakes. 6 strawberry shortcakes. 7 pumpkin pies. 8 raspberry pudding desserts. 9 coconut custard pies. 10 chocolate layer cakes.
I'm gonna paint it too.